All right, well, I think maybe we can begin. Hello, everyone. Good morning, good afternoon, good evening, wherever you are in the world. I'm Erin Daly. I'm the Executive Director of Dignity Rights International, and on behalf of myself and my colleague, Professor Jimmy May, I'd like to welcome you to the first gathering of the Dignity Law Reading Group, sponsored by Dignity Rights International. For those of you who are not yet familiar with DRI, we're a small nonprofit organization dedicated to helping people around the world claim and protect their dignity rights through education, advocacy, and consultation. You can learn more about DRI at dignityrights.org. And I'd like to invite you to watch for forthcoming events that will shortly be announced. Today, we are absolutely thrilled to be able to inaugurate this Dignity Law Reading Group series with the launch of Dina Lupin-Townsend's wonderful new book, Human Dignity and the Adjudication of Environmental Rights. And we are doubly thrilled to have Dina join us today. I think this book is truly extraordinary. As you'll see, Dina really pushes us to rethink both sides of her title. She elucidates and enriches our understanding of human dignity and even of what it means to be human and our relationship to our natural environment, and then examines the practical implications of these observations in the context of adjudication. A few details before we begin. First, importantly, we will be providing a flyer with a 35% discount for the book for those of you who have not already received it. We will ask everyone to silence their microphones, but keep your videos on if possible so that we can feel like we're having a real conversation. Dina will speak for a short while and then we'll have time for questions and conversation. You're welcome to use the chat function to post questions, or we can have a more impromptu conversation after Dina's formal presentation. We will be recording this event mainly so that Dina can have it, but please let me know if further distribution poses any kind of difficulty for you. Without further ado, let me introduce Dina Lupin-Townsend. Dina is a postdoctoral researcher in the philosophy department at the University of Vienna, where she is investigating practices of silencing and epistemic injustice in consultation processes. She has actually just finished a second book, so we're going to have to start planning the launch of that very soon, a short monograph on gender and climate change information services. Dina works closely with me as the Deputy Director of the Global Network for Human Rights and the Environment, and she also runs a consultancy practice advising governments, universities, and companies on their environmental and human rights obligations. This all sounds very formal, so I just want to say Dina is also just an extraordinary person who just is one of those people who makes you smile, but also think really hard every time you talk to her. So it's just a real pleasure for me to welcome Dina to this and to help launch her book. So please join me in welcoming Dina Lupin-Townsend. Dina, the floor is yours.
Thank you, Erin. Thank you everyone for being here. It's so nice to see you all. But really a special thanks to Dignity Rights International, to Jimmy and to Erin, who've been such friends and supporters of this project from its very early days. Erin has even flown across the world twice, I think, in support of this project. And it really, it wouldn't be what it is without them. So I couldn't think of a nicer place to be launching this book. I wish, of course, we could do it over champagne and cake, but we'll maybe do that for the next one. So I'm gonna talk about the book a little bit. I'm gonna sort of give an overview of what I think are what I think is kind of the argument in the book that is most sort of significant to me. And then, as Erin says, we can chat about it, and if you have questions about particular parts of it, or if there are particular areas we want to focus on, we can do that. I can dodge your questions a little bit later. So my book starts, as you might know, and if you haven't read it yet, the first chapter is available free of charge online. My book starts with me and Thelma and Kosi, who Thelma was my client at the time. I was working for an organization called the Center for Environmental Rights, which is an environmental legal clinic based in Cape Town. And it starts with me and Thelma standing on the edge of this huge open cast anthracite mine that was established on community land that had belonged to Thelma and her community. And the mine had been established without the proper licenses, without environmental impact assessments, without communication or consultation with the community, through processes that kind of involved bribing traditional leaders and through the kind of sheer incompetence of government officials. And it was just this sort of huge gaping hole in the landscape that we were staring at. It was like staring into the negative of a landscape. And as we stood there just sort of trying to take it in, Thelma says to me, look how they've taken away our dignity. And as I say in the book, I was very struck by this comment, and I wrote it down in the case file because it felt like such a profound expression of the violation that had happened to Thelma and her community and to the environment. But it also felt like that is what I was looking at. I was looking at the kind of absence of a landscape, but also at the absence of dignity. And kind of unbeknownst to Thelma and me at the time, this comment was going to send me on this long, fascinating road in which I set out to try and understand human dignity and bring dignity into human rights, environmental rights adjudication, and into environmental disputes. Because it seemed to me when I started this project that human dignity, which is often seen as sort of the foundation of human rights, the sort of reason we have rights is that they're an expression of our dignity. It seemed to me that human dignity had been doing very important work in human rights adjudication in relation to a wide range of human rights. So cases on the death penalty, cases on euthanasia, cases on abortion, on rights to privacy, on rights to housing, on voting rights, a very wide range of rights in a very wide range of jurisdictions. So both in international courts and in many domestic courts, dignity was really being put to work by human rights courts and lawyers, and many significant human rights cases were turning on dignity arguments. But that was not the case at all, as far as I could tell, in environmental rights cases and environmental disputes. There is kind of an absence of value reasoning in these cases generally, but dignity in particular seemed to be missing. There was no consideration in these cases of what they meant for dignity, what the connection might be between our environmental interests and our dignity interests. And so what I thought I was going to be doing when I started this project was simply taking this sort of well-established human rights value and kind of bringing it into environmental rights adjudication. But something that happens very quickly when you devote yourself to the study of human dignity is that you realize that dignity is not as kind of well liked or widely accepted as it sort of initially seems to be. There are many people, practitioners, but also scholars, who deeply dislike and distrust the idea of dignity. And people don't like dignity for a number of really good reasons. Dignity is often seen to be rooted in Western, even imperialist ideologies of a sort of highly individualistic idea of human worth. Dignity is often just seen to be pompous and self-aggrandizing, a way for judges and lawmakers to regulate behavior that they see as kind of undignified. But probably the main complaint that's raised against dignity is that it's it's seen as a concept that sort of really doesn't have any meaning at all. It's seen as an empty vessel that both kind of does too much and means too little. And I think Michael Rosen at Harvard University is maybe one of the main proponents of this argument. And his big objection is that dignity will mean whatever the person who's using it at that moment, whatever the person who's making the argument in that moment wants it to mean. And as a result, dignity ends up appearing on opposite sides of the same argument. And we do see that in the case law. So there was, for example, a famous European case on euthanasia in which dignity arguments were made both for and against euthanasia rights. That's also true for rights related to abortion. Dignity arguments have been used both for and against rights to abortion. And while I've written what is in some sense as a kind of book length defense of human dignity, I don't disagree with this sort of basic objection. I do think dignity is subject to a wide array of interpretations, and that it does get used on both sides of the same argument. But while Rosen thinks that's what's wrong with dignity, while he thinks that renders the concept kind of fundamentally corrupt, I think that's what's great about dignity, that dignity is kind of open to a wide range of interpretations and applications. Seems to me to be both useful because we can think about what we want and need dignity to mean and do in the context of human rights law. But it also seems to me to be appropriate because I think what human dignity really does is it points to a question, particularly in the context of human rights law, and that question is, what is the human of human rights? What does it mean to be human, and why does that matter? And I think dignity's sort of conceptual openness reflects the sort of openness in our own self-understandings, that our understandings of ourselves and of our dignity and of what it means to be human is something that is not sort of defined once and for all at some moment in time, but is a kind of evolving process, and that we are kind of always becoming. We're not a fixed quantity, but rather, as Richard Rorty puts it, we're a fuzzy but promising project. And so it seems to me that seeing dignity as kind of without a very sort of precise meaning, as pointing us more to questions than to answers, is particularly useful, because what it means we can do is we can revisit and rethink about and reinterpret dignity and use it in new ways, depending on our context, depending on what's happening, depending on what threats we face to our human rights. And I suggest in the book that we're at a particularly important point in history when we need to come back to dignity and think about it again, to sort of consider and reconsider what it means to be human and what this demands of us. And I think there are many important sort of factors, there are many important contexts in which we might think about dignity right now. We might think about what dignity demands of us, what our humanness demands of us in the context of pandemic. And we might think about what dignity sort of means in the context of rising populism. But the sort of main context that I consider dignity in the book is in the context of new environmental threats. So our rights face unprecedented threats from environmental change, from climate change, from the destruction of biodiversity. And we're at a moment when the world is changing kind of rapidly around us, where the ways we live and the ways we kind of function as societies is going to change enormously. And so this feels like a crucial moment for us to be thinking about what our humanness demands of each other, what our obligations are, and what our rights are in that context. And so in the book, I kind of set out to do that. I set out to revisit and reinvestigate the notion of dignity in the context of these new environmental threats. And my approach to dignity is one that is both what I try and do in the book is I try and give an account of dignity that is both relational and emplaced. But I'm just pausing because it's not, my goal is not to do what Rosen sort of demands and give a definition to dignity, but rather it really is an approach. It's a way of thinking about and interpreting dignity. So as I say, rather than a kind of a very individualistic conception of human worth, of sort of very decontextualized, ahistoric idea of inherent worth that's often associated with Kantian philosophy. My approach to dignity is to see it as both relational, as dependent on as constituted in our relationships with other people, but also as emplaced, as constituted in our relationship with the world, with the environments in which our lives happen and unfold. And I approach this, I sort of develop this argument in the book by firstly moving away from sort of classic conceptions of dignity found in Western philosophical traditions and looking to other traditions, to other ways of thinking about humanness. And I start with African philosophical and legal traditions and notions of humanness found in those traditions that are rooted in community, and the idea that we are constituted by and emerge from our relationships with others and our kind of belonging in society. So this is an idea of dignity that's often, in a Southern African context, expressed through the notion of Ubuntu, and the South African Constitutional Court has relied on this idea quite a lot in its talk of dignity. And it's an idea that's sometimes expressed through the saying, a person is a person through other people. It's a kind of idea of selfhood, or an idea or an approach to understanding our rights and obligations that is linked to our place and roles in community. And I find in the book that this isn't only an approach to dignity that we find in African and increasingly African legal and philosophical traditions, but also in contemporary human rights reasoning. So I look at the way in which courts have interpreted and applied dignity in a wide range of rights jurisprudence, in cases on marriage and family life, on torture, on rights to work, on housing, on privacy. And I look at the ways in which courts kind of interpret dignity and think about dignity in their rights reasoning. And what I find is that a kind of very social conception of dignity is already at work in judicial reasoning. Courts connect rights to marriage, to family life, to housing, but also political rights to our places in society, and sees us as kind of constituted in, as sort of forming our self-understanding and our identities in relationship to other people, to community, and particularly to the ways in which we are accepted or excluded from society. So I start then with this relational account of dignity, but I want to build on this idea of dignity. I mean, I think a relational, I think a kind of collective count of dignity is already important when thinking about environmental rights cases, and when thinking about sort of collective interests and goods that often come up in environmental rights cases. But I don't, but what I do in the book is I build on this account of a relational understanding of dignity, arguing for an understanding of our humanness as not only constituted in our relationships with others, but also in our relationships with the environment, and particularly with the places and spaces in which our lives take place and unfold. And I argue that our very subjectivity, the kinds of thinking, acting, experiencing beings that we are, depends on our engagements and interactions with the world in which we live. Our mental lives depend on our engagement with our surrounding environment. And our identities and self-understandings are constituted in the particular places we inhabit and encounter, in the places we cross over. And so I argue that we are, in quite a kind of fundamental sense, placed beings. So as I say, I give this account of dignity as kind of both relational and in place, and I think that this has a number of important implications. One of which is that it begins to change how we think about what constitutes violations of our dignity. So when we are, so a kind of relational and in place understanding of dignity means that when we are removed from our communities, when we're torn from our families, when we're socially isolated, our dignity is violated. But equally, when we're torn from our environments, when we're forcibly displaced from the places we know, or when our environments are radically altered and damaged around us, when they're, for example, transformed from community land to anthracite mine, our dignity is demeaned, and we're stripped of our sense of relatedness to others, but also to our environments. And when that happens, we're stripped of our dignity. And as I say, I think this has a number of important implications for how courts ought to think about and approach and adjudicate environmental rights disputes. And in the book, I try and apply this idea of dignity that I develop into increasingly common environmental rights contexts. The first case concerns the rights of Indigenous peoples, asserting rights to property, rights to territory over their traditional lands, particularly in the face of extractive industries and kind of rapid development of alternative energy projects. And the second concerns cases about future generations, in which the rights of future generations become a factor in judicial reasoning. And this is happening increasingly. That's increasingly appearing in litigation, not only in climate change litigation, which is its own sort of rapidly growing area of legal development, but also in cases about land conservation and forced removals and banking practices and genetic engineering, and a wide range of other cases are increasingly considering the rights and roles of future generations. And what I find when I look at these cases, and I discuss a number of them in the book, but what I find is that environmental rights disputes are almost always framed as a matter of a clear-cut conflicting interest between two parties. They're treated in our kind of adversarial legal system like contract cases. They're seen to concern a conflict between two parties, but also sometimes between sort of competing priorities. So between development and conservation, or between present and future generations, between rural and urban communities, or between Indigenous communities seeking to protect their territory and the state seeking to develop hydropower dams. And in bringing my account of dignity to bear on these cases, I argue not only that thinking about our dignity interests as environmental interests allows courts to integrate and to sort of elevate environmental concerns, but also that a relational and emplaced account of dignity undoes or undermines this idea of clear-cut conflict at work here. Because it's an account of dignity that sees us as kind of in a very fundamental way, as kind of tied together to each other, but also to our environments. Our dignity depends on the dignity of others and is threatened when the dignity of others is threatened. And our dignity depends on how we treat our environments and how we access those environments. So when we see ourselves as constituted in our relationships with others and in our relationships with the environment in this way, then our interests can no longer lie neatly on kind of one side or the other of these conflicts. Dignity remains, as Michael Rosen objects, on both sides of these conflicts, but that, to my mind, doesn't show us the inadequacies of dignity so much as the inadequacies of legal adjudication that frames our kind of fundamental human rights and environmental interests as in conflict with each other. And I thought, if you would indulge me for another 2 minutes, that I would read a little part of the conclusion to you where I make this argument. I'm inordinately proud of the conclusion because I spent months not being able to write it, and then I woke up at 2 o'clock one morning and wrote the whole thing between 2 a.m. and 5 a.m. and it's the only piece of writing I've ever written that I haven't needed to edit or change. So that's why you're about to hear some of it. So, bringing dignity into environmental matters does not make their resolution easier, nor does it offer simple, direct solutions. If anything, dignity reasoning complicates adjudication in environmental cases, challenging assumptions about the distinction between human rights and environmental concerns, revealing the interconnected nature of public and private interests. While some will see this as the greatest weakness of a dignity approach, I argue that it is in fact its greatest strength. This book is, in a manner of speaking, an appeal for greater complexity rather than simplicity in our environmental adjudication. All too often, environmental problems are solved by framing them as a competition between different interests: private or public, human or natural, environmental or economic. Dignity, however, demands that judges face the enormous complexity that defines many environmental rights cases. Many environmental rights cases bring into the courtroom the great social dilemmas of our time, and treating such cases as simply disputes between litigants may amount to a critical social failing on the part of the judiciary. It is precisely dignity's elasticity that should make it attractive to those adjudicating environmental cases. Recognizing that dignity protects competing interests requires courts to decide matters with full regard for all the interests dignity protects. Taking dignity seriously must entail full consideration of the ways in which dignity is demeaned and the complexity of protecting it. While dignity may make some cases harder to adjudicate, this greater difficulty in environmental judicial reasoning is appropriate. Adopting a dignity approach means eschewing the idea that environmental cases, particularly cases that implicate resources of global concern, can be resolved by simply weighing up the competing interests of different parties, recognizing instead that both parties, and indeed many others impacted by the case, have dignity interests on both sides of the matter. Thank you.
Thank you, Dina. That was just fantastic. First of all, please join me in thanking Dina for this really wonderful sort of survey and investigation and introduction to the kinds of work that she's been doing in that book. So a global round of applause, please, for Dina. Thank you so much. We all definitely wish that we could be there in person and share a glass of champagne with you to launch this. But we're also sort of really thrilled that I think the Zoom format of this has enabled lots more people to gather from all different parts of the world to enjoy this. So, so I'm thrilled for that on the bright side. We really are, I think, so fortunate to have front row seats to this, as Dina is really, you can see, just pushing through to new and richer and more profound ways of thinking about the most important issues of our day and for the future. She's asking us to seriously think and rethink about nothing less than what it means to be human, not just as a theoretical or philosophical matter, as if we have nothing better to do these days than contemplate these things. Excuse me. But knowing that this matters. It matters when our land is taken, when we're forcibly displaced, when we're torn from the places we know, as she says. And how those kinds of environmental changes in environmental conditions, which we're obviously seeing more and more of all over the world and in different ways, how those kinds of changes strip us of our dignity. And then she goes further and asks us to consider what the law and courts in particular should do about this, and critiques sort of the courts in specific cases, but also sort of in general, for viewing some of these most profound questions as win-lose questions, as binary problems that have a single simple solution. And she resists the simplicity of all of this. So I think that she's just given us so much to think about and so many sort of different avenues to go down. I am inviting questions in the chat, and we already have some. So I'll do that. I would like to start actually with one question, and just to ask you to sort of elaborate on it a little bit, because it's a different way of thinking about rights than people often do. People tend to think about rights as the thing that I can demand from someone else, the thing that I'm entitled to. And you used a phrase a couple of times about trying to understand or exploring what does our dignity demand of us, and what does it demand of each other? What does dignity demand of each other? And I'm just wondering if you can explain that a little bit, sort of in the context of rights, and how you mean to sort of reverse the directional obligations, maybe.
Thanks, Erin. So I think that one of the implications of thinking about kind of dignity as, yeah, so classically often we think about rights as things that we demand of the state, particularly. But one of the features of environmental cases is that they often do involve the state, but they also often involve individuals, corporates, neighbors, but the interests that we have in environmental cases also extend significantly sort of beyond the state. So something you see in environmental cases a great deal is the court sort of making use of the idea that there is a public interest in some horrendous environmental destruction, and kind of the worst version of that I think I've seen is when the African Commission is adjudicating a case relating to Shell's kind of horrific human rights violations in the Niger Delta, which has been nothing but a curse for most Nigerians. They sort of say, you know, of course Nigerians have a great interest in the extraction of oil in the Niger Delta. Sort of think, do they? But I think that our kind of what we can ask of each other and what we can demand of each other features very strongly in environmental cases anyway. And I think that a kind of idea of dignity, if you start with an idea of sort of dignity as connected and as relational, or as sort of tied to your place in society and community, then you can't think about rights without thinking about what you owe others in that community as well. And certainly this is a very strong feature of many sort of African customary legal traditions that I draw on in the book. But it's also sort of an important part, I think, of the development of environmental legal thinking is that rights require us to also think about obligations. And I think that's more true than ever, sort of in the context of climate change, that addressing climate change requires sort of extraordinary sacrifice on the part of governments and corporations, but also on the part of all of us. And to my mind, that kind of demand for sacrifice is a rights request. It is about realizing rights at a kind of interpersonal level.
Thank you so much. We have a number of questions in the chat. I'm going to just skip around a little bit because there's another question that seems to me to sort of follow from this discussion, which is about the role of power in relation to dignity. And the question is this, and you can all read it, but I'll just read it out loud. At first glance, power seems at the core of what's really important about dignity, having a say about yourself and your environment and your community. But perhaps power is already, quote, implied in the concept of dignity in a way which makes discussion of it in relation to each other isn't necessary anymore. So I'm wondering if you can just elaborate a little bit on the relation that you see between power and the dignity issues that you're talking about.
Sorry, I'm just reading the question.
The question's from Sarah. I jumped just because I thought that the question about power sort of connected a little bit to what you were just talking about, sort of rights, responsibilities, and the implied power in there.
I mean, I think it's a really interesting question. Because the idea of power that Sarah seems to be gesturing to is kind of the idea of empowering. Sarah's pointing at Annalie. So this idea that dignity is sort of empowering, having a say about yourself and your environment and your community. Perhaps dignity is. I mean, it's interesting. So the work that I'm doing at the moment is very much about who gets to speak and who gets to be believed and tell their stories in particularly in processes of consultation aimed at environmental decision making, and those kinds of processes are very much seen as expressions of dignity. They're kind of they recognize your personhood. They give you kind of an opportunity to be an active decision maker, to be involved in the decisions that affect you. And what we're seeing in those processes more and more is that instead of them being ways in which people can tell their own stories and assert their own interests, they in fact become processes by which people are effectively silenced. They say their piece, and then their piece kind of sort of disappears. They're simultaneously sort of an expression of dignity and a denial of dignity, in a manner of speaking. I don't know if power is implied in the concept of dignity in a way which makes relations of it in relation to each other unnecessary. I mean, it seems to me that it's kind of very important when we're thinking about a social and relational conception of dignity, how we engage with each other and the way in which those engagements are framed by power dynamics. I'll give that some more thought. Thanks for the tough one.
Obviously very difficult questions, but I have a feeling that's not the only difficult question that you're going to be facing here. But I want to follow up on something that you said and the work that you're currently doing about public participation and the role of public participation. And Matoma Kappa has a question that I think is related to that. A big aspect of Matome's work is teaching communities affected by mining and other polluting industries about their rights and practical remedies they could use to vindicate their rights. I think dignity is an important aspect of environmental justice. So my question is, how can affected communities use dignity as a tool to vindicate their rights?
I think that's a great question. I think that dignity can do a few things. and I think it can do a few things in a very sort of applied way. So one of the things that that dignity does is that it kind of instantly elevates the issue to a question of sort of fundamental core rights concerns. When we talk about our dignity rights, and this is something that Erin's written about much more than I have, but when we think about our dignity rights, what we think about is those rights that are most fundamental to us. They're kind of fundamental to what it is to be a person, and to be recognized as a person. And so using the language of dignity, I think not only in court process, but also in consultation processes, but also in protest, expresses the relationship between what one's demanding, and often what one's demanding is some kind of sort of basic environmental protection concern, and one's humanness. And I think that what happens, Matomi talks about communities affected by mining and polluting industries, and I think what happens often is that people's dignity is used kind of against them. So the talk behind sort of extractive industries, not only in South Africa but all over the world, is that this is absolutely necessary for the dignity of workers. These are industry creating, these are job creating, and so what happened to Thelma, certainly, and I write about it in the book, but what happened to lots of communities is that their dignity becomes a reason for their environmental rights to be violated. We do this so that you can get some really horrible job in a mine. And I think kind of reclaiming that language and sort of framing one's interests in land and in sort of not living in polluted environments as dignity interests, kind of challenges that discourse, but also points to the sort of fundamental importance of the issue. So I think it's important that for example, mine-affected communities start using this kind of language in their activism, as well as in their legal actions.
Thank you. I think there's definitely a lot more to be said about all of these issues. So just sort of, I view these as sort of opening questions that we can all sort of go off and think more about and maybe do more with. There's a couple of questions in the chat about the relationship between human dignity and rights of nature. So I'm wondering if you can address that.
Yeah, I think this is a really interesting issue, and one that I kind of don't deal with in the book. So there are some scholars who've argued that we ought to be sort of extending our understanding of dignity to account for kind of the dignity of nature, the dignity of plants or animals, and I think that's very interesting. But I think there's something interesting to be said, sort of particularly about human dignity and about sort of understanding our humanness as discrete but not separate, if that makes sense. And so that's sort of what I do in the book. But I think thinking about rights of nature becomes very important for dignity in certain circumstances. And I'm going to sort of unhelpfully just give an example and then not say anything else about it. So as I said, the current work I'm doing is on participation and the ability of people to speak about themselves and their needs and their experiences in the context of environmental decision making. And I read about a fascinating community who are the women in the community. They're an indigenous community, are river keepers. So their role is to is to look after the river, this particular very significant river, but also to speak to and with and for the river in sort of traditional lawmaking forums and in decision-making processes. But they're not speaking about the river. The river's speaking through them. They're the voice of the river, and it struck me as kind of a particularly interesting area to think about the rights of nature, because of course the rights of rivers have been recognized. The rights of other sort of particular environmental areas or mountains have been recognized, but we're still sort of working out, it's a kind of very new idea, I think, in environmental law, and we're still sort of working out what that means in practice, what that means in litigation, who gets to say when those rights are violated. But this is a case in which the river has a voice. You know, the community says the river has a voice, and the river has a way of speaking. These women are the voice of the river. And so then I started kind of thinking about, you know, whether one can think about rivers having not just sort of rights, but very particular rights to participation. Does this river get to tell its story in environmental decision making? And if it does, you know, like what does that even mean? And is that an expression of dignity, and whose dignity? All of which is to say interesting, but yeah, something to think about more.
Yeah, well, very, very serious and difficult questions. Another question, and again, I'm going through the questions in the chat, but I invite people to chime in if they'd like to, or just to make it even more challenging for Dina. But if you have follow-up questions to some of these, to some of, you know, her answers and her reactions to these, I think that would be really, really great and really interesting. And I'm sure Dina would welcome it. I'll speak for you. There's a couple of, one question in particular that I think is sort of brings us down a little bit in terms of from the sort of big philosophical inquiries to focusing on specific cases. And the question is whether you can refer to a couple of European cases that you discuss in your book.
Sure. Just going to crack open the bibliography. So I look at cases from the European Court of Human Rights, and I also look at a couple of European cases that ended up at the Human Rights Commission, and of course, because I'm nervous, I can't think of any of their names off the top of my head, but there are a few cases. I'm assuming you mean dignity cases, because environmental cases are very limited, and the European Court of Human Rights has been very reluctant to sort of very directly address environmental questions. So it has, in a case, for example, stipulated that there's no environmental right in the European Convention on Human Rights, and as a result, it won't entertain environmental rights questions. But it does indirectly. It's heard cases on pollution, and it's heard cases on toxic waste, and it's heard cases on the protection of areas, and it has decided them through, particularly through the rights to private and family life. But the court also has quite a rich dignity jurisprudence, including on the rights of LGBTIQ populations in various aspects, rights to marriage, but also particularly the rights of trans individuals to be identified in the way they sort of see themselves, and so identity and dignity is tied together in those sorts of cases. that doesn't answer the question. I'll be happy to send an email list of case names.
So,
Sorry.
can I just jump in a couple of quick thoughts? One is that if you go to the link on Edward Elgar where the book is, I think that the index is there, and I think you can probably see some of the cases if you're just looking for names of cases. But I just want to sort of pick up on something that Dina said about the European Court of Human Rights not recognizing environmental rights per se, but recognizing them through family and privacy, and at the same time having this sort of rich commitment to dignity. And it just seems to me that implicitly then, by saying that the environment is really about family and how we live close to the people that we want to be the closest to, that they're coming to dignity, they're connecting dignity and environment in a certain deep way without necessarily acknowledging it or sort of making that at the foreground of its jurisprudence, but sort of connecting these ideas that Dina's talking about dignity being relational and emplaced and experienced often through how we experience family. So just sort of a thought that I think it's there, even if it doesn't say it's there. And I guess, so a couple of other questions that have come in. One is, after all the congratulations and the kudos, well-being seems to be a strong connector between dignity and environmental rights. And would you be willing to share your thoughts on the role of well-being in this relationship?
I mean, that's interesting. I guess there's a question about what you mean by well-being. When I wrote my argument when I wrote the part of the book where I kind of developed this notion of in place dignity, I draw quite heavily on pragmatist philosophy, but particularly on an Australian philosopher named Jeff Malpass, who has developed this sort of topographical approach to dignity. And this in-placed idea of dignity. So I really sort of draw quite strongly on that. And, you know, where I wanted to go with that argument was that when you harm the environment, you harm us, and that's a problem. And where Malpass seems to go with that argument is that, you know, sometimes bad things happen, and that's humanizing. And so I kind of found that a little bit sort of discouraging, because he seems to think that sort of part of our humanness is suffering, in which case, you know, well-being, take it or leave it. No, but I think there's sort of lots of aspects of well-being, and often the right to environment is connected to sort of very fundamental aspects of our well-being, sort of our capacity to live in a healthy environment, to live in an environment that isn't sort of threatening to our life and lifestyles, and I think that dignity, that there's something, and we see this a lot in the South African jurisprudence, there's something kind of very fundamental in dignity that we see sort of people living in situations of suffering, in conditions of poverty and hardship, as kind of fundamentally demeaning and undignified. We see that as kind of a violation of our dignity. I think it's L.B. Sachs in particular, the South African Constitutional Court judge, has written a number of judgments where he argues that leaving people in conditions of poverty, in conditions in which their well-being is so entirely neglected, is to sort of not only demean their dignity, it's not only a complete violation of their dignity, but a violation of all of our dignities. We are both in our just kind of being in a world in which people are allowed to suffer, but also sort of being implicated in various ways and allowing that suffering. It demeans all of our dignity. And I think that speaks to sort of well-being, both as sort of the basic necessities of life, the need to be able to meet our basic needs, but maybe also something sort of more than that. Maybe also sort of living well, living in a way that reflects our humanness. Yeah, so I think there is an important connection there.
There's another question that that maybe in some ways should have been the first question, but I think also actually follows very much from what you were just talking about just trying to understand the connection between dignity and all these other things. And this is about the fact that you say that you do not offer a definition of dignity. And my immediate question was, how do you apply the concept in the absence of specifying it specifically, or specifying what it is? How do you see, however, you do seem to at least partially define or at least specify some features of dignity, in particular that it's relational and that it's connected to place. And this clearly offers some guidance for applying the concept. However, since you do not offer a full-fledged definition of dignity, and here's the question, this is the hard part, is it possible that the concept includes other elements that might conflict with the two features that you've defined? In other words, is it possible that there can be internal conflicts with the concept itself? Perhaps, for instance, that dignity is individualistic, which might conflict with the notion of it being relational, or perhaps that it can be detached as opposed to connected to place. So how do you deal with those sort of, the possibility of internal conflict within the meaning of the word itself?
Yeah, I think that's right. I think dignity harbors both many meanings and many conflicts. And my approach to it, I didn't really talk about it today, but a sort of key part of my understanding of dignity and sort of my defense of dignity even is seeing it as a kind of very complex and multifaceted concept, and and sort of not demanding that dignity always does the same thing in all cases. I think that the kind of inherent sort of tensions and conflicts that you are talking about there are there in our sort of personhood, in our self-understanding. We do sort of both we do sort of think about ourselves and constitute ourselves sort of in a very sort of lonely individual, not lonely, that sounds negative, but in a very sort of we have relationships sort of with ourselves, and we also we are also kind of constituted in our relationships with others. I mean, I'm not sure that these things are sort of necessarily in tension. I think when one can think about dignity as kind of multifaceted and as sort of gesturing to many elements of humanness, all of which will not be necessarily relevant or important in every case or use of the concept. And I don't think that that's sort of a problem for dignity, but also I'm not sure that these things are kind of really conflicts. You know, we can think about relationality sort of in a triangle, is how I talk about it in the book. You know, we have relationships with others, we have relationships with the world, and we also have relationships with ourselves, and sort of navigating that, knowing ourselves, coming to sort of some sense of self-understanding is sorry, now I've lost the phrase I had in my mind, that we can kind of navigate what it is to be sort of an individual and individualistic without that meaning that we have to think we're no longer constituted in our relationships with others. And so sometimes these sorts of tensions are not sort of necessarily tensions. They're just sort of facets of this sort of very complex selfhood. I think I do a better job of responding to that question. The book, read the book.
No, I think you did a fantastic job of responding to it, because I mean, ultimately what you're saying is that this whole subject that we're talking about, human dignity, is really about the human experience. And there's no reason to expect that to be easily defined or sort of just about one thing. It's about being individuals, but about being relational. It's about being sort of in ourselves, but also in the places that we're in. And that makes it a challenge as we try to think of this, not just as a philosophical concept, but as something that's doing real work in courts and in law. Thank you again. I just want to thank everybody for joining us today, and thank Dina for just doing a marvelous job introducing us to this concept. Please do read her book. It's fantastic. You have the links both to the book itself and also to a flyer that will give you a discount on it. And so I just want to thank everybody for joining, and Dina, that was just wonderful. You've given us just so much to think about. So thank you to everybody. Have a good rest of your day or evening.
Thanks, everyone. Thank you, Erin.